morning. Welcome to the Senate Commerce and Consumer Protection Committee, March 26, 2026, last day before deadline. We start with Senate File 4401, Senator Dibble. Welcome to the committee, Senator Dibble. Senate File 4401 is in front of us.
Thank you, Mr. Chair and members, for the opportunity to present Senate File number 4401. Mr. Chair and members, we do have an A1 and an A2 amendment, which I can describe before you adopt, if you like. Very quickly, so the A1 would be a delete everything amendment. The A2 then would be just a technical little bit of fix up to the A1, and it would then, if it is adopted, it would bring together 7 bills that have been presented to this committee previously, and those include Senate Files 4541, which has to do with supply chain streamlining, Senate File 4519, which has to do with local government regulatory clarity, Senate File 4540, licensing and enforcement improvements, Senate File 4429, which has to do with labeling updates and has some to do with hemp. Senate File 4401, which is updating the nature of reporting that's expected and required of the Office of Cannabis Management. Senate File 4402, which has to do with data practices. We just talked about that a couple days ago. What should be kept made public and what should be kept non-public. And Senate File 4403, which is a series of technical and housekeeping updates. I'll just add also that there was some overlap between 4540 and 4541, and so some of those overlapping issues were made more consistent with each other. So that's the A1, and we can go into more detail if we like. So, Mr. Chair, the A2 is, I confess I don't completely understand, but as it's been explained to me, it's just technical. As I glance through it, it's just replacing some words for other words and things like that.
Thank you, Senator Dibble. Any questions on the A2? Senator Wiklund offers the A2. All in favor say aye. Aye. Opposed? It's adopted. Any further summary of your bill, or Director Taubel, any comment?
I'll just mention that for those paying super close attention, we did hear 4542 that has to do with event licensing. That's in finance, so we didn't pick that one up in this package.
Questions from the committee? Senator Rasmusson.
Thank you, Mr. Chair, and thank you, Senator Dibble. I just wanted to reiterate my concerns around some of the canopy limit changes that are in the underlying bill. I'm not going to rehash that argument, but I noticed in the DE that the language was the same that we had heard previously, and I just still have concerns around access for medical patients and also just fairness and having stability in the market. So for those reasons, we'll be opposed to the bill today.
Senator Duckworth.
Thanks, Mr. Chair. Just briefly, I don't know if it's an oversight or not, but on the agenda, I thought for sure by now we'd see Senator Dibble listed as an honorary member of the committee. Any other comment on the bill? Senator Seaver moves.
Waiting for some people to come online.
I have a cup of coffee. I'm content.
Mr. Chair.
Senator Frantz.
Thank you, Mr. Chair. I think your microphone's partly off for me. Thank you, members of the committee. Thank you, Mr. Chair. Thank you, Senator Dibble. Senator Dibble, I got a copy this morning of a March 27th 2026 letter from Vireo Health Inc. It's a letter to you, but was sent to me by advocates expressing some concerns. I just want to ask if you've had a chance to look at that record, and if you have any thoughts we can share with that stakeholder. Thank you, Mr. Chair. Thanks, Senator Dibble.
Senator Dibble.
Thank you, Mr. Chair. I have not seen that letter. Mr. Chair, I'm not sure if it's been sent to me yet or not. I did receive a text from Vireo's lobbyist, and of course their concerns are similar to the concerns of Green Thumb, and they're of the nature that Senator Rasmusson raised in the hearing a few days ago. I understand and am sensitive to those concerns. My goal, of course, is to keep this bill moving, and my pledge is to work through those issues.
Thank you, Senator Dibble. Thank you, Mr. Chair. That pledge is good enough for me. I can support the bill moving forward. I do not understand the supply chain and efficiency topics as well. I too will put in a little bit of time if it helps. So thank you, Mr. Chair, for the chance to address that.
So, Mr. Chair.
Senator Dibble.
My pledge is to spend some quality time on the phone with Senator Frentz over the holiday or the break, if you would so desire.
That would be great. Thank you for that, Senator. Thanks, Mr. Chair.
He's a no. Should I just lay it over? For now. We'll pick this bill up a little later. For now, it is laid over.
Great. Thank you, Mr. Chair and members.
Senator Rasmusson. Senator Rasmusson, Senate File 4496 is in front of the committee.
Thank you, Mr. Chair, and I appreciate the opportunity to move up in the agenda given some other committee hearings this morning. The bill before the committee modernizes Minnesota's telecom statutes to reflect today's broadband-driven marketplace. It removes obsolete telephone-era regulations, reduces barriers to development, and aligns state law with federal standards. I want to thank the Department of Commerce and the Public Utilities Commission for working with the Minnesota Telecom Alliance to find and identify obsolete language, duplicative requirements that are no longer needed, and to identify those in this bill. Mr. Chair, I do have an amendment that reflects the consensus and the work with the Department of Commerce and the Public Utilities Commission. So I would like to move the A1 amendment as an author's amendment, which is a delete everything amendment.
Senator Rasmusson offers the A1 author's amendment. All in favor say aye. Aye. Opposed? Senator Rasmusson.
Thank you, Mr. Chair. And we do have a section by section summary, and I'm happy to go through with that, but I can also hand it over to my testifier to offer any comments.
Mr. Christensen, welcome to the committee. Introduce yourself.
Thank you, Mr. Chair and members of the committee. For the record, my name is Brent Christensen. I'm the president and CEO of the Minnesota Telecom Alliance. We're a trade association that represents over 80 independent telephone companies throughout the state of Minnesota. In the interest of time, I'm going to dispense with reading my written testimony and just kind of tell you about how we got to where we are. We started about 6 months ago and went through Chapter 237, and we did it under three lenses. One is the sections in that statute, are they technologically obsolete? Two, are they now anti-competitive? The statute was written or adapted over 40 years ago, 10 years before competition came to our industry. And third, does it line up with federal rules and law? So we went through it section by section, and we came up with things that we thought should be repealed, things that we thought should be adapted and changed. I'll just give you one quick example. There's a statute that requires us to trace calls when we're required to by law. We don't have that technology anymore. We can't tap onto a phone line like we used to be able to because of IP technology. We have now federal requirements that we have to conform to that is called the Communications Assistance for Law Enforcement Act, and that is that is more up to date than what we have in law. So we've changed the language to adapt to that. Once we got done with that, we met with the Department of Commerce, who've been a very collaborative partner in this whole process, and went through it and came to things that we could agree to that needed to stay in, things that needed to get out. And then after that, we gave it to the Public Utilities Commission. So collaboratively, we worked with Commerce, and I want to thank them for that, and the Commission as well. So I think we have a agreed upon bill that's the first step in modernizing telephone regulation. Once we do this, I will be back next year with rules that we need to repeal and adapt to do this. But the first thing is to get the statute going. So I want to thank Senator Rasmusson for bringing this forward. And with that, Mr. Chair, I'm happy to stand for any questions.
Thank you, Mr. Christensen. Any questions or comments from the committee? Senator Rasmusson, where do you want this bill to go?
Thank you, Mr. Chair. I would move that Senate File 4496 as amended be recommended to pass and be sent to general orders.
All in favor, say aye.
Aye.
Opposed? Senator Rasmusson.
Thank you.
Senator Port. Welcome to the committee, Senator Port. Senate File 4711 is in front of us.
Thank you, Mr. Chair. Preventing invasive discriminatory surveillance pricing is one of the best, most obvious things we as a legislature can do for Minnesotans this year. The practice of using consumers' data to price the same product differently for different people is new, and it's spreading fast. Grocery chains across the country are rapidly rolling out electronic shelf labels, essentially digital price tags that can change in an instant. With the help of AI, these electronic price systems can pull in a massive amount of personal data and open the door to surveillance pricing, or charging different customers different prices based on who they are or when they shop. Even the name surveillance pricing is disturbing. The idea that we're being watched, that big corporations and big tech have eyes on us everywhere, are collecting our names and our faces, sharing and selling our personal data and using it against us. Kroger has 60 million household profiles by its own admission and is now selling that household data to advertisers and other businesses. With electronic shelf labels, companies can change the price of an item at the drop of a hat without any warning. Prices could spike at peak hours when companies know the stores will be full of customers looking to shop quickly. Electronic shelf labels can change so quickly the price of an item can change before a customer reaches the cash register. Everyone deserves to pay the same price for the same product. Charging different prices to different people is discrimination, plain and simple. With the cost of living continuing to rise, the last thing families need is price gouging at the airport or at the supermarket. ESLs also threaten grocery workers' livelihood. These systems could replace the skilled workers of grocery clerks, or at the very least, leave them to explain a company's actions to angry shoppers. I'll just briefly sketch out what practices would be regulated under the language of this bill. Grocery stores would be prohibited from using electronic shelving labels, from engaging in specialized pricing based on algorithms or customer surveillance, or even from collecting data on minors under 17 and from using that data on a protected class to set the price of a good. Here's what the bill explicitly allows. If a store wants to use your purchase history to offer a lower price, we are not going to stand in the way of anyone and their loyalty rewards. I'll close by saying this bill feels like a continuation of our work banning junk fees in 2024. Surveillance pricing is part of the same playbook to undermine consumers' ability to shop in their best interest. I'm also encouraged by bipartisan collaboration on legislation regulating AI and data privacy. It's an issue all Minnesotans and all Americans are worried about across the board. That's why I pushed and asked for this hearing before deadline, because I would love to continue working with this committee. I don't think we want to move the bill forward. I think we should lay it over and continue talking about it to make sure that we're making the best decisions as we move forward, but I appreciate the committee's time, and I think there are a few testifiers.
Thank you, Senator Porter. And we will go to testifiers. I would agree with you that the members of the plan will be to lay this bill over today. The work of overseeing and regulating predatory pricing and surveillance pricing is essential and urgent, and certainly the purview of this committee. This particular bill, I'm grateful that you're going to continue to work on it with our retailers and with our friends in labor and try to get it just right. So with that, I'll call up Justin Stofferin and Rena Wong. Welcome to the committee, Mr. Stofferin. Please introduce yourself and proceed.
Thank you, Chair Klein and committee members. My name is Justin Stofferin with Minnesota Farmers Union. I appreciate the opportunity to share some thoughts today on the issue of surveillance pricing. MFU is a grassroots organization that's represented family farmers, ranchers, and rural communities since 1918. Back then, farmers came together to ensure they received a fair price for what they produced. But the fight for fair pricing in Minnesota dates back even further to the 1870s, when farmers successfully pushed the legislature to curb personalized and discriminatory railroad prices. That same era produced the price tag, establishing the uniform pricing consumers have come to expect and is key to a fair and democratic economy. In fact, 83% of Americans believe that businesses should charge all consumers the same price for the same item. Surveillance pricing threatens to undermine that expectation and erode the very concept of prices, which also undermines efforts to provide real discounts. A recent Consumer Reports investigation into Instacart reveals how surveillance pricing tactics can be used to increase costs on consumers. Following that investigation, the Trump administration's Federal Trade Commission said, quote, "Like so many Americans, we are disturbed by what we have read in the press about Instacart's alleged pricing practices." Surveillance pricing could also create a more unlevel playing field as big tech firms move to integrate AI agents into retail decisions, deciding where to shop and what brands to purchase. This opens up a future where small businesses, like your local grocer, are squeezed out by agreements between tech companies and dominant retailers. In competitive markets, surveillance pricing would not be nearly as attractive a strategy, but in consolidated markets, this is a powerful mechanism for gouging consumers. And unfortunately, the economy's been rapidly consolidating, particularly in grocery, where just 4 firms control over half of sales. So thank you, Senator Port, for your work on this issue. We look forward to working with you and the committee on the language to make sure it addresses some of the things I've outlined today and to address the unfair pricing methods driving up costs for Minnesotans. Thank you.
Thank you, Mr. Stofferin. I don't see Ms. Wong. Is Jordan Blomquist? Oh, there she is. All right. Welcome to the committee. Please introduce yourself and proceed.
Thank you. Good morning. My name is Rena Wong. I'm the president of the United Food and Commercial Workers, Local 663. And thank you for taking the time this morning to hear the comments and concerns of our members. It is really important for our members that we keep groceries affordable for all Minnesotans and that we protect good union jobs that provide family-sustaining wages here in the state. And we believe that AI-powered electronic shelf labels and surveillance pricing will hurt Minnesotans and hurt workers. Because the industry likes to say that we are trying to stifle progress and that we need to be able to compete. And the reality is that we're not trying to do either thing. We believe progress is good. We believe that we can do that, however, responsibly, because electronic shelf labels and AI pricing is not going to be the thing that saves us, right? It is not actually going to improve prices. It will not improve the shopping experience. I think folks who've been in stores and seen all those self-checkouts know that that's the case if you've ever shopped at a grocery store. And data privacy is really important. AI surveillance pricing is not going to improve individual privacy, and it is going to be workers who pay the price of moving towards electronic shelf labels, because it is these jobs, these good union jobs that help to keep our members in their homes with health care and with secure retirement. And the only thing that will improve is the bottom line for big grocery stores like Walmart, the mom and pop shops that we all love for us and in our membership, like the Olmsteads, the Oxendales. These are not the stores that are going to be benefiting. It is the Walmarts of the world. And so we would like folks to remember that in talking about this issue, that it was here in St. Paul where experts actually found that online grocery shopping platform Instacart was conducting pricing experiments, charging different prices for different customers. They found that prices varied by nearly 7%. And just for context, that's the equivalent to nearly twice the total rise in food prices in the Twin Cities over the last 3 years. And so if we have learned anything over these last 20 years, it is that big tech does not deserve the red carpet treatment in our grocery stores and in our communities when they are putting affordability at risk in doing so. And so electronic shelf labels, surveillance pricing is something that we need to very carefully consider, and we look forward to continuing to work with Senator Port, who's been an amazing champion on this issue, as well with lawmakers on both sides of the aisle, to really think about what is this threat that is facing Minnesota workers and families, how we put guardrails on it. And UFCW members are united against these harmful predatory technologies in our grocery stores and in our communities.
Thank you, Ms. Wong. Can you make room for Mr. Will Hagen, testifiers? Let's keep our comments to about 2 minutes. Mr. Blomquist, please introduce yourself and proceed.
Good morning, committee members. My name is Jordan Blomquist. I am here today to testify in support of SF 4711. I currently live in Stillwater, but I grew up in Minnesota. I've lived here my whole life, and I'm a proud member of UFCW Local 1189. I started working in grocery retail in 2015 when I was hired as a part-time meat department clerk at Festival Foods in Hugo. Over the next 3 years, I worked my way up to become a journeyman meat cutter. Today, I manage the meat department at Nolan's in South St. Paul because I have the protection of a union contract that guarantees me fair wages and benefits. I'm able to support myself and my partner and build a stable life here in Minnesota. South St. Paul is a blue-collar community. Most working families are on a very tight budget. When grocery prices go up, people feel it immediately. You can see the stress on customers' faces as they shop, trying to stretch every dollar that they can. And when there's confusion or frustration about prices in the store, customers are not looking for a corporate manager in an office. They look to the first worker they see, the clerk, the stocker, the cashier, the meat cutter, and they expect answers right away. That puts frontline grocery workers in the middle of pricing disputes that we don't control, and it creates tension and conflict in stores. This is why we cannot allow large grocery chains to use electronic shelf labels and pricing practices that can lead to inconsistent or unfair pricing. Every Minnesotan deserves to pay the same fair price for food as everyone else. Thank you for the opportunity to testify today, and I respectfully urge you to support SF 4711.
Thank you, Mr. Blomquist. Can you make room for Steve Barthel?
Absolutely.
Mr. Hagen, please introduce yourself.
Chair Klein and members of the committee, thank you for the opportunity to testify. For the record, my name is Will Hagen with Minnesota Retailers. We represent retailers of all sizes across the state, from small Main Street stores to national brands. And I'm here to express our opposition to SF 4711. At its core, retail is one of the most competitive sectors in our economy. Retailers succeed by delivering value and experiences to customers, not by increasing prices on individual shoppers. Consumers today are smart and savvy, comparing prices instantly both in-store and online, clipping coupons and saving through loyalty programs. They're making decisions in real time and at checkout. Price matters. Decisions on what, where, and when to buy all hinge on competing to deliver the lowest prices. That competition disciplines pricing. The idea that retailers raise prices on different individuals simply doesn't reflect how today's market operates. Retail is built around helping a customer find value, and if a retailer price is too high, customers leave, sometimes permanently. We also want to be clear on a principle we hear from all our members. Retailers should not use an individual's data to increase prices for that individual. That's not how retailers build trust or long-term relationships with their customers. The concern is that this bill, as drafted, risks sweeping in the very tools that customers rely on to save money. Digital coupons, loyalty discounts, targeted promotions. These are not tools to raise prices. In fact, they are the primary ways Minnesotans access lower prices. If the language is too broad, those tools could be limited or chilled. And if that happens, the impact doesn't show up in theory, it shows up in the shopping trip. Fewer discounts, fewer promotions, less ability to adapt and find savings. For price-sensitive households, that's real. I also want to touch on electronic shelf labels, or ESLs, because they're part of that same experience. ESLs are not about price manipulation. For shoppers, ESLs mean the price on the shelf matches the price at checkout. They mean fewer errors, clearer information, and more confidence in what you're paying. They are, in actuality, about accuracy and transparency. Pricing accuracy is already in Minnesota law, and ESLs help retailers meet that standard. ESLs don't change prices, they display them. And they help retailers meet pricing accuracy requirements while freeing up employees to spend more time helping customers and not swapping out paper tags. Finally, the bill introduces unclear definitions around surveillance pricing and data use. That creates uncertainty for retailers trying to operate in good faith. And in a business with tight margins and constant cost pressures driven by supply chain, global markets, and tariff changes, limiting the ability to adjust prices and offer discounts in today's competitive market can ultimately increase costs. So when we think about this bill, we ask to keep the Minnesota shopper in mind. The one walking the aisles, scrolling on their phone, looking for value, making trade-offs, relying on discounts to make it all work. Chair and members, we understand the intent behind this bill, but as written, it risks making it harder, not easier, for customers to afford their lives. We would welcome the opportunity to work with the author and the committee to find solutions that support affordability and make Minnesota competitive for all. Thank you.
Thank you, Mr. Hagan. Mr. Bartel.
Good morning, Chair Klein and members of the committee. My name is Steve Bartle. I am Director of Government Relations for the Minnesota Grocers Association. For more than 125 years, the MGA has been proud to serve as the leading voice for Minnesota's food industry. Today, our membership includes more than 250 member companies, including many of the locally owned retailers Minnesotans have come to know as trusted household names. We appreciate the opportunity to testify with our opposition to this bill and hope that we can shed some light on a few of the misconceptions that are the basis for the proposal. Proponents of this bill have suggested that grocers are tracking shoppers throughout the stores, and if they use electronic shelf labels, can target individual customers and change prices in real time. Simply put, our members do not have the capability, resources, or desire to engage in such practices. This bill also reflects a fundamental misunderstanding of how retailers succeed in the highly competitive grocery market. Success isn't driven by charging the highest price a customer is willing to pay. It comes from attracting and retaining loyal customers by delivering an exceptional shopping experience, offering quality products, and keeping prices as low as possible. You can't build or keep customer loyalty without trust. In the grocery industry, the fastest way to lose trust would be to start monkeying around with prices. Picture yourself in the aisle of your favorite grocery or convenience store. You watch another shopper pick an item, then as you reach for the same product, the price suddenly changes, whether up or down. How would you react? I'm willing to bet you'd walk out of that store and never come back. Supporters of this bill also have an inflated perception of the capabilities of electronic shelf labels. Most common ESLs are about $10 a piece. They are much more akin to an e-reader or a Kindle than they are to a smartphone. When a price is updated in a store's system, it still takes 90 seconds to 2 minutes for an ESL to reflect that change. ESLs provide a more efficient, environmentally friendly, and accurate way to display prices. They eliminate the need to manually print and replace paper tags, a significant task to carry on in stores that average more than 32,000 items, and greatly reduce the staff time required to do routine pricing updates. However, ESLs still require a dedicated pricing team to manage and update shelf prices. The notion that AI could replace our skilled store associates who are essential to keeping stores running smoothly and delivering an exceptional shopping experience is simply wrong. We understand the desire by legislators to address affordability and increasing costs for consumers this session, but particularly when it comes to grocery. But the causes behind the rising costs of groceries are not a mystery. Go talk to your local grocery manager and they'll tell you. Since 2020, labor costs have increased by more than 20%. Commercial electricity rates are up 22%. Natural gas prices have risen 30%. Theft is still a significant issue in many of our stores, and commercial property taxes are up all across the state. All of those factors are outside the control of the businesses and continue to drive up operating costs and the price of goods. It's not greedy grocers driving up prices. They operate in an extremely competitive market with razor-thin margins of just 1.5% to 2%, selling items that primarily cost between $2 and $6. Retailers are constantly seeking operational efficiencies to mitigate these growing costs. ESLs are just one such tool. We do not believe the legislature should be restricting ESL technology in an effort to prevent a practice, surveillance pricing in brick and mortar stores, that is not occurring. Thank you again for your time and consideration. We happily invite any of you to tour your local grocery store and see firsthand how pricing works in brick and mortar settings, and to see why making Minnesota the first state to ban ESLs would be misguided and would do nothing to improve affordability in the state. Thank you.
Thank you, Mr. Bartle. Senator Frentz.
Thank you, Mr. Chair, and thank you, Senator Port, for bringing this forward. I do believe the surveillance pricing is a legitimate issue, and you have my support for the work you're doing to prevent, as Senator Murphy said, 2 different people from being charged 2 different amounts for the same bananas. My concern is on the question of the ESL, and I've had some advocacy. I noticed the Star Tribune yesterday, Senator Port published an article which referred to a study, and I'm hoping to ask your thoughts on it. The study was under the subheading, Research Shows Concerns Could Be Overstated. And it says, a study analyzing hundreds of millions of transactions across more than 100 Walmart and Kroger stores found, quote, virtually no, close quote, evidence of real-time surge pricing before or after digital labels were introduced. I want our brothers and sisters at UFCW to win our support and protection. I consider myself a supporter of organized labor, but I'm a little concerned that we're out over our skis on this issue. Senator Port, are there other states which have banned ESLs, and can you shed any light, if there are, about how that's gone since that ban? Thank you, Mr. Chair. Thanks, Senator Port.
Senator Port.
Thank you, Mr. Chair, and thank you, Senator Frentz. I can't speak to that study, having not seen it or known who you did the study. Or what the metrics were. But what I will say is we would be the first state to ban ESLs. To my understanding, though, it is moving through legislatures in several other states across the country at this moment. I think we are in a moment where technology is moving incredibly fast, and how AI is being used and how our data is being used is changing very rapidly. I do think if we're going to look at this from a point of consumer protection, it's important that we do look at what the capacity is now, but also how it is shifting incredibly quickly. Literally month to month, there are changes in what is possible. So I do think, while we would be leading in this, I don't think that's necessarily a bad thing. And I certainly am open to the conversation about the ESLs and banning them completely versus banning the predatory practices of price discrimination. And I do think it's important to note that while grocery stores have very thin margins, and there are a lot of things pushing on them right now, not least of which is the cuts to SNAP, which grocery stores rely in Minnesota between 9 and 12% of their sales on people who use SNAP benefits. So with those SNAP benefits going down and people being removed from the program, that is a significant loss of income for our grocers. So I do think there are a lot of things currently pushing on pricing, including tariffs and the price of gas to move products across the country. But we should be thinking sort of broader and more forward-looking at how we can protect customers.
Other member questions or comments on the bill?
Mr. Chair.
Senator Frentz.
Thank you again, Mr. Chair, and thank you, Senator Port. You spoke directly to the concerns, and well done by you. Count on my support again to ban surveillance pricing where individual data is used. Count on my cooperation to work with UFCW and retailers to find some answers on ESL. We have, of course, relationships with these retailers who sell food, and you're right, they are under intense pressure, and there are a lot of other factors. Maybe we can talk about that at a different hearing, but for today, appreciate your work on this. Count on my support and count on my collaboration to the extent it's necessary. I want to ban artificial intelligence where it's harmful, and I want Minnesota and our country to get the benefit of artificial intelligence, and to, where it's not, to do it. And it's tough. Senator Port, you've seen in your work a lot of the ways where it's more difficult than it sounds. My hope would be to protect retailers' ability to improve efficiency. And if ESLs can do that without abridging our rights as consumers and support working men and women, I'm all in. Thank you, Mr. Chair.
Thank you, Senator France. Other member questions or comments? Thank you, Senator Port, for the work on the bill. Again, surveillance pricing, a big problem. It's the jurisdiction of this committee to address it, and I encourage your continued work. Do you have any closing comments?
Appreciate the committee's attention today, and more than happy to work with any of you. I'll reach out to Senator France and make sure that we continue to find the best path forward for this legislation.
Senate File 4711 is laid over. Senator Duckworth. Senate File 4652 is in front of the committee. Senator Duckworth.
Thank you, Mr. Chair. I appreciate it.
Sorry, Mr. Senator Duckworth. Senate File 4168 is in front of the committee.
Okay. I'm ready for curveballs, Mr. Chair. Thanks. I appreciate the opportunity to present Senate File 4168. Before I begin, I do have an author's amendment, A1, Mr. Chair. I'd like to move, please.
Senator Duckworth offers the A1 author's amendment. All in favor say aye. Aye. Opposed? It is adopted. Senator Duckworth.
Thank you, Mr. Chair. I promised to be brief, so I will. This bill is about financing options for those who are looking to make real estate investments for themselves. Let me start off by saying that predatory lending absolutely has no place in the state of Minnesota. This bill certainly is in line with that. It removes the caps on prepayment penalties as well as financing closing costs or lender fees for those who are purchasing or looking to purchase non-owner occupied investment property. I know that can seem counterintuitive, but this bill is all about presenting consumers options and making purchasing real estate for the purposes of investment more affordable. It's one of the greatest ways for families to generate wealth for them and their loved ones. Just another update for the members of this committee to know, the folks at Legal Aid helped craft the very amendment that we just put onto the bill, which has now made them neutral in regard to it. It's my understanding that all stakeholders have had some collaboration and deliberation on the bill, which has made them all neutral of it. And it has also moved successfully with unanimous bipartisan support in the House as well, just to let folks know where this bill currently stands. With that being said, Mr. Chair, with me today is Mr. Mike Stidham, and I'm going to let him explain the bill in more detail. Thank you.
Thank you, Senator Duckworth. Mr. Stidham, please introduce yourself and proceed.
Yeah, for the record, my name is Michael Stidham. I am the Director of Regulatory Affairs with Rocket Mortgage. Good morning, Chairman Klein, members of the committee. Rocket Mortgage appreciates the opportunity to provide testimony in support of the proposed amendments to the Minnesota Mortgage Originator and Servicer and Licensing Statute, which would specify that the finance lender fee caps and prepayment penalty restrictions are only for consumer purpose loans. The first restriction the bill addresses, again, is the 5% limit on the finance lender fees. Under current Minnesota law, lenders are not allowed to include a lender fee in the principal amount of a residential mortgage loan in excess of 5% of the amount to be financed. We agree that while the protections regarding lender fee financing for personal, family, or household purposes, collectively a consumer purpose loan, are important, the ability to finance these closing costs, including lender fees, can be a beneficial option for real estate investors using a business purpose mortgage loan. Senate File 4168 does not increase fees that can be charged. Rather, it permits borrowers to have additional flexibility to finance those fees and free up capital needed to come to the closing table, which will make it easier for small investors to start or continue investing. The second restriction the bill addresses is the limitation on prepayment penalties. Under current Minnesota law, the prepayment penalties are limited to being charged within the first 42 months after closing and cannot exceed the existing caps. We agree that prepayment penalties charged on consumer purpose loans can be an undue financial burden on consumers. However, a prepayment penalty can be a beneficial tool for borrowers looking to obtain more favorable upfront pricing on business purpose mortgage loans. Specifically, loans with a prepayment penalty receive lower upfront pricing, it's lower interest rate or closing costs, whereas loans without the prepayment penalty are going to be priced higher to offset potential returns if a loan is paid in full earlier than anticipated. The prepayment penalties are a great tool for keeping monthly payments lower for those who are planning on holding that investment property. It reduces house flipping and it increases stability in the housing market. So Senate File 4168 will retain the 5% limit on finance lender fees and the limit of prepayment penalties to be charged within the first 42 months for consumer purpose loans. So that concludes my testimony, and I'm happy to answer any questions you may have.
Thank you, Mr. Stidham. Any questions or comments from the committee? Senator Rasmusson.
Thank you, Mr. Chair. I don't know if this is for the bill author or the testifier, but with this exemption, is there any limit on fees for this type of loan that we're talking about?
Mr. Stidham.
Through the chair, there currently is not any caps on fees. And this bill does not introduce additional fees to be raised. It's a very competitive mortgage market that all lenders are in, and consumers do shop different lenders to try to find the best deal that's right for them. So this in no way increases any fees whatsoever. There's no caps currently. There's no caps with the bill. And again, it's a very competitive market, and we're trying to do everything we can to reduce housing affordability. I mean, to attack a housing affordability. It's the #1 issue that we're seeing in all the states, and we're trying to do whatever we can to relieve that in any way we can.
Senator Rasmusson.
Thank you, Mr. Chair. I'm a little confused, and so I want to make sure I understand the bill. So it's my understanding that this would exempt a certain type of loan from our consumer statutes that have a 5% cap. But I just...
That's correct.
So this would allow...
This would be for business purpose loans, specifically a debt service cover ratio loan. That's specifically what the exemption is for.
But, and Mr. Chair, this is the problem I've had with this bill and similar bills when we have testifiers who can't say what the bill actually does. This bill increases fees. That's okay. I'm not talking about why we need to have caps on fees or not, but this is lifting a current 5% cap to unlimited. That's what the bill does. And I just wish that we could have testifiers that could present the information as what's in front of us, unless I'm mistaken, that this removes the fee cap.
It removes the fee cap, but it doesn't increase the fees. It allows an individual to be able to finance those fees if they so desire, that it goes above 5%. And on DSCR loans, typically the fees are going to be above 5%. So the way it is today is that you can finance up to 5%, but the rest of it you'd have to bring to the closing table. This would allow the individual, if they have the equity in their property, to be able to finance all the fees and not come to the closing table with those fees.
Senator Rasmusson.
Thank you, Mr. Chair. And so what this does is that it allows the company to amortize fees above the fee cap, which in my view is no different than just charging a higher interest rate. However, when people are looking at these different loans, they compare interest rates across different entities. I'm glad that the amendment was adopted because the original bill would have exempted a whole swath of personal loans, family loans, household loans from the fee cap. So again, I just, with this bill, I just think we need to talk about what it does and what it doesn't do when it comes before the committee. This is not about saving consumers money. It's actually about how that you can charge a higher fee and then amortize it into the principal. I'm not even necessarily opposed to that, but that's what the bill does.
Yeah, this bill does not increase fees.
Mr. Stidham.
Yeah, I'm sorry. This bill does not increase fees. It allows the optionality if they have enough equity in the property to be able to finance those fees, because some investors want to retain as much liquidity as possible, so they would rather finance it.
I have a question for the author. You mentioned that the bill has the support of legal aid, and it was our understanding as well it had the support of Ron Elwood and other interested parties. Can you confirm that?
That is affirmative.
If I may, Mr. Chair, I know they were instrumental in helping to put the amendment on there. I won't speak for them. I think the word that was conveyed to me was neutral, so I don't want to overstate. But I'll also elaborate sort of on the conversation a little bit, if that's okay. although I did promise to be brief, so I'll stick to that promise.
Senator Duckworth.
Folks may not know this about me. I'm a licensed real estate agent, been helping people buy and sell homes for over a decade. I have investment properties myself. And what I have seen in the housing market, whether it's in the state of Minnesota or across the country, is prices have gone up, affordability continues to be a challenge, and when prices go up and you talk about the down payment percentages on a home, it becomes more and more difficult for people to achieve that down payment cash on hand, whether it's a personal residence or in this case we're talking about specifically investment properties only. All the consumer protections that exist in state law for people who are buying their personal residential properties still exist. This bill does not aim to seek to change any of that. This is specific to folks buying in, real estate for investment purposes. And what happens is right now they don't have an option to potentially take some of the fees that are involved in any real estate transaction, enroll it into what would be their payment over time. And for some folks, that's actually an option they would prefer. Well, right now they don't have that option available to them. So in order to keep more cash on hand, they might seek to use the option this bill would provide them, or to help make that down payment cash amount more achievable, they could roll it into the fees over the life of the loan, for example. All that to say, I can appreciate different perspectives that folks have related to this bill, but as somebody who works in this industry and has for many years, what I see it as is a bill that provides folks option, provides them choice. They're not mandated to utilize this service or other loan products out there that they may choose instead, but this would give some folks an additional option who are seeking to invest in real estate here in the great state of Minnesota.
Senator Duckworth, that's compelling that they're not required to choose these
Correct.
loan products, and they choose to take one that has a loan fee cap. They can certainly do that.
Absolutely.
Senator Rasmusson, any further comments? Senator Rasmusson? No, it's fine. Any further comments? Senator Heisman.
Thank you. On 1.5, it says it doesn't apply to residential mortgage loans, but on 1.7, I think that someone could self-declare that it's for investment purposes, that it's just a self-declaration that this is for the investment purpose. And then 1.8 and 1.10 do that they can't occupy or continue to occupy, but for how long? So if a residential mortgage loan individual wanted to go get a loan, they see this attractive lower interest rate that they want to take advantage of, so maybe they see the loophole of saying, this is an investment property, but then I just won't occupy it for the time while I'm getting the loan, but then how long are they restricted from living in that home? I don't see that in the bill language. Or if I bought it and a family member lived there and then I chose to visit them, I don't know how that works out and if that's a loophole that consumers could utilize.
Mr. Stidham.
Yeah, the DSCR loan prohibits the consumer to occupying the property at all. So even if you bought a multi-unit, a 2-unit, or 3-unit, you couldn't occupy one of those units as your primary residence. That's one of the features of the business loan is you cannot occupy it, period, for no time whatsoever.
Senator Heinzman.
While it has a mortgage or ever?
Ever.
Further discussion from the committee? Senator Duckworth, you have a motion, I think.
I do, Mr. Chair.
I can say it for you if you'd like.
Please, if you don't mind, just to make sure we're on the same page.
Question is on the motion of Senator Duckworth that Senate File 4168 is amended, be recommended to pass and sent to general orders. All in favor say aye.
Aye.
Opposed? Motion is adopted. Senator Duckworth, we'll move right on to Senate File 4652.
Thank you, Mr. Chair. I appreciate it, and thank you, members, for that discussion. I really do appreciate it. Moving on to Senate File 4652 is a common sense, no-cost bill that gives Minnesota banks and credit unions a great new tool to protect customers from financial fraud and exploitation. It creates a voluntary trusted contact program so customers can designate one or more trusted family members or friends that their bank may contact if red flags appear on the account. I have with me Tess Rice, MBA's General Counsel, with me today to go into more detail regarding the bill, Mr. Chair.
Welcome to the committee, Ms. Rice. Please introduce yourself and proceed.
Mr. Chair, committee members, I'm Tess Rice, MBA's General Counsel. MBA is a trade association that represents about 95% of the banks in Minnesota, from the largest to the very smallest. Thank you to Senator Duckworth for carrying this bill, and also to the Department of Commerce. They helped us with the language, and we incorporated their suggestions into it. This is a fraud prevention bill. We all know fraud is increasing dramatically. The FTC estimates fraud in Minnesota against consumers increased 24% over the last year, and similar number the year before that. So it's a really big problem, and we're hearing from our bankers that they're actually provisioning more for losses from fraud than they do losses from loans, which is a big change. So this is meant to be a practical tool to help banks if they spot fraud. There will be a trusted party that the customer has named who the bank can reach out to and say, hey, we see fraud on this account. We can't get a hold of the account owner. This language came out of Missouri, and we're hopeful that it will make somewhat of a dent in the amount of fraud that we're seeing against our bank customers.
Thank you. Yeah, no, thank you, Senator Duckworth, for the bill. It seems like an important and simple measure to protect against senior fraud. So good work. Any questions from the committee? Questions on the motion of Senator Wiklund, sorry.
Sorry about that. I just had a question about how much definition is there in terms of how someone becomes a trusted contact? Like who puts together the guidelines for how a person would become a trusted contact, and who kind of oversees that?
Senator Duckworth or the testifier?
Do you want to handle that?
Ms. Rice.
Mr. Chair, Senator, so the bill authorizes a bank to offer a trusted contact program where the customer would name a trusted contact. They could opt into this. So this is completely optional. They can also take away that appointment if they wish to do it. This program could be as big as letting these people see what's going on in the account, not conducting any transactions, but viewing what's happening. But it will be up to the bank and to the consumer to determine what access they want to give that trusted contact.
If I may, Mr. Chair.
Senator Duckworth.
And I appreciate the question, Senator Wiklund, because that's one of the questions I had regarding the bill was, are we authorizing somebody to take action regarding this account? And that's not the intent of the bill. The bill is, if there is some fraudulent activity that a bank suspects is occurring and they can't get a hold of the account owner or the account custodian, there is a designated person who the bank can reach out to and contact simply to say, we're noticing fraud potentially on this account. We can't get a hold of the account owner, so we're notifying you to help us get in touch with them and contact them, not to authorize any activity on the account, but simply for an awareness sake, so that person can also be made aware regarding what the bank has discovered.
Senator Wiklund.
Thank you, Mr. Chair. I guess what I was more getting at is, like, when these programs are set up, is there anyone who will oversee, like, what the program is and how it's established and what documentation the person receives about the program? I mean, it seems like in subdivision 5, there's like limited liabilities that are included. And I'm just wondering how do we know how the banks will set up this program? Like, is there anyone who oversees that part of the process? So there's some standardization about what is a trusted contact, or isn't there? Is it purely up to each bank to decide, like, I want to establish a trusted contact program, and a group of people at the bank sets it up?
Ms. Rice.
Mr. Chair, Senator, it is designed to be very flexible. So the idea here is that we're trying to encourage banks to offer these programs to their customers to prevent fraud. And so we've tried to make it flexible for them, so it will be how they want to do it. Some banks are doing this already, but not enough because they are afraid of liability issues. And so this is just meant to, they are overseen, of course, very closely by the Department of Commerce, by FDIC, Federal Reserve, or National Bank by the OCC, so they are watched very carefully.
Senator Wiklund.
No other question. I guess it just gives me a little pause that this is something that can be set up, and then it can provide to a person, you know, a certain set of principles, but then there's not really anybody confirming that these are the right ones. And yet it gives the banks, you know, certain liability, removal of liability. So I guess I just have some concern about how that will all work out, you know, that people can have confidence that their bank has set it up in a way that they really understand, and that the giving away this liability makes sense. So that would just be a concern of mine.
Any other questions from the committee? Closing comments from Senator Duckworth.
None, Mr. Chair. Thank you.
Question is on the motion of Senator Duckworth that Senate File 4652 be recommended to pass and sent to general orders. All in favor say aye.
Aye.
Opposed? Aye. It's adopted.
Thank you, Mr. Chair and committee.
Senator Wiklund. Welcome to the committee. Senate File 4419 is in front of us.
Thank you, Mr. Chair. Senate File 4419 is a bill that was brought forward by the Department of Health. It has many or several different provisions in it related to different aspects of Department of Health regulation and some of the things they're responsible for. And so I will let my testifier go through the bill and talk about the commerce-related provisions especially. So.
Welcome to the committee, Ms. Timian. Welcome to the committee, Ms. Timian. Please introduce yourself and proceed.
Mr. Chair, members of the committee, for the record, my name is Lisa Timian, Director of Government Relations at the Minnesota Department of Health. Thank you so much for taking the time to hear this bill today. The department is bringing this forward to take up several pieces to address stability and access, reducing administrative complexity, strengthening our prescription drug transparency program, and protecting vaccine access for Minnesotans. For federal conformity, we're aligning drug authorization standards and transmission requirements for drug prior authorization exchanges with established and broadly used national standards and federal requirements. We're also adding clarity and simplicity by making an existing statutory exception permanent. There has been an annual exemption for the past 16 years, exempting from state requirements routine healthcare business data among healthcare providers and group purchasers and intermediaries known as clearinghouses. This exception has been renewed annually with no controversy, and making this exception permanent eliminates this annual process. Because this committee deals with insurance, these are like the medical insurance pieces of workers' comp, for instance, or car insurance. So this is just exempting them from these requirements. We're also removing obsolete language and repealing obsolete statutes, as well as modifying reporting requirements to our Prescription Drug Price Transparency Act to ensure that Minnesota continues to lead in transparency and accountability in drug pricing amidst a quickly evolving market. We're also streamlining and aligning our HMO statutes because they predate most of the model law language, and this is really technical and correcting cross-references. We're also doing some network adequacy technical cleanup. Last year, the legislature updated statutes to align with federal time and distance standards, and we just needed to add some additional clarity for all the provider types that are subject to these federal requirements. And lastly, I want to talk about immunization coverage. Thank you again, Senator, for your leadership this year on ensuring Minnesotans have access to good vaccine information. Because vaccines are considered preventative, they're for routine use are required to be covered by health plans that are regulated by state. They're covered if they have been recommended by the CDC's Advisory Committee on Immunization Practices or the Centers for Disease Control and Prevention. Historically, this schedule has been widely accepted and supported by all major medical associations. However, structural changes to the committee over the past year has raised questions from medical associations, and there is doubt that ACIP will continue to represent scientific consensus. This proposal will continue to recognize ACIP recommendations, but will also require coverage of vaccines if they are recommended by any of several major medical associations added to the statute.
Thank you, Ms. Timian. Is Hannah Seitzinger present? Welcome to the committee. Please introduce yourself and proceed.
Good morning, Mr. Chair, members of the committee. My name is Hannah Seitzinger, and I'm with the Healthcare Distribution Alliance, representing wholesale distributors. Our issue with Senate File 4419 stemmed from subdivision 14, lines 8 through 10. Sorry, can you hear me? Lines 8 through 10, which was specific to data reporting requirements that wholesalers don't have a clear line of sight to. However, I'm happy to report we've spoke with the department prior to committee and are actively working on a solution. We've also submitted a letter that goes more in depth on our issue, but would just like to thank Chair Wiklund and the department for their continued work.
Thank you, Ms. Seitzinger. I didn't fully hear your comment, but it sounds like you've come to make
Yes, we've come to, we are currently working on a solution.
Any questions or comments?
Mr. Chair, I forgot, I do have an amendment, the A4 amendment. No, because this came from HHS, we heard it. And the A4 amendment, basically it makes the language conform to what we have included in my Omnibus policy bill. So this language is traveling in both HHS, the Omnibus policy bill that I have going, and we wanted to make sure the language stays the same. And council can, I guess, if you want to provide any more details. But.
Senator Wiklund offers the A4. Questions or comments on A4? All in favor, say aye.
Aye. No.
So the motion is of Senator Wiklund that Senate File 4419 is amended, be recommended and passed and referred to the Committee on Health and Human Services. All in favor, say aye.
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 No. It is adopted. Senator Dibble.
Thank you so much. I think I can talk more about it.
Senator Dibble, Senate File 4401 is in front of us.
Just thank you, Mr. Chair, for the conversation. I've now seen the Vireo letter, and it says exactly what I thought it would say, and I'll just reiterate that I'm sensitive to all of the competing perspectives on this matter, and will continue to work diligently on resolving the issues.
Members who are voting online, please turn on the cameras. Questions on the motion of Senator Seeberger that Senate File 4401 is amended, recommended pass and sent to Committee of Finance. Questions on the motion of Senator Seeberger that Senate File 4401 is amended, be recommended to pass and sent to the Committee of Finance. All in favor, say aye. Aye. Opposed? No. Motion is adopted. Thank you, Senator Dibble.
Thank you, Mr. Chair, members.
Senator Rest. Senator Rest, Senate File 4687 is in front of us.
Thank you, Mr. Chairman. Last year, we established the Consumer Protection Fraud Act, whereby victims of consumer fraud, a fund was established from penalties, et cetera. They're paid through the Attorney General. And since that time, $4.6 million has been distributed. What this bill does is take away the limit of $5 million on leaving the 50% of the money that is otherwise collected from these fines, and sets up a different schedule of paying out the restitution funds so that if a loss amount is $25,000, then $25,000 is paid up, and the total loss would be paid up to $50,000 between, if the loss amount, for example, is $80,000, the current loss says $80,000, we would reduce that to $50,000 plus 50% of the amount above $50,000. And if the amount was $2 million, the proposal limits the restitution to $100,000. It allows more victims to be included, but since before, it was kind of like the first come, and you could, if you had a huge loss, you would get a lot of that back, and it limited the number of people that could be served by it. And that is the bill. It's supported by AARP, and their representative is here if you have any questions.
Thank you, Senator Ress. Does Mr. Elness want to testify or just to be available for questions?
It's not, well, he's here, but it's really not necessary.
Just for questions, okay. Are there questions from the committee on Senate File 4687? There are not. Question is on the motion of Senator Ress that Senate File 4687 be recommended to pass and referred to the Committee on Finance.
Yes.
All in favor say aye. Aye.
Aye. Thank you.
Senator Ress.
Senator Klein, welcome to the Commerce Committee. Two-year bill, Senate File 4366.
Thank you, Chair and Committee, and appreciate the Friday work. This is the Department of Commerce's policy bill on unclaimed property, and I will turn it over to Sam Smith from the department.
Mr. Smith.
Chair Seeberger, members of the committee, my name is Sam Smith, and I'm here to testify on Senate File 4366. We were able to make meaningful progress towards achieving a significant update to state law governing unclaimed property. As a part of that work, I'd like to thank the Minnesota Bankers Association, Bank-In, the Minnesota Credit Union Network, MIFC, SIFMA, and everyone else who worked with us on this issue. I look forward to continuing this work over the interim. There were enough unresolved items to push this work into the summer. I am glad that we were able to advance a few key items this session in the delete all amendment, which we still need to adopt. I remind myself of this, it's been a long week. This includes incorporating virtual currencies into unclaimed property statute, creating a fix for unclaimed burial insurance benefits, and exempting 529 plans from state statute. And happy to answer any questions.
Thank you, Mr. Smith. Senator Klein, I believe you had an A1 authors amendment. Is that correct?
Madam Chair, I offer the A1 as an author's amendment.
All right. All those in favor of adopting the A1 authors amendment, say aye. Any opposed, say no. The amendment is adopted. All right. Any questions or comments from members of the committee? Senator Dames.
Well, thank you, Madam Chair, and I hope that the Department of Commerce, and as you're working on this, and I understand you're going to continue to work on it this summer, that you do something to make it easier for people to claim their funds. I've had more calls of people trying to claim their funds, and they just get sick of the fight and just say, forget it, they can have it. And we really need to do something about that. This is a program where we're supposed to be able to get these unidentified funds, or I shouldn't say unidentified, I should say that have not been passed out, to the people that rightfully own those. And so I don't know why we have to have so many roadblocks in order to try to stop that. And many times the comments I get is, why do we even have that department? Because they're just going to wait until the time they can put the money in the bank for themselves, and we're not going to get it. I myself have had some real problems with getting money out of there. It just needs to be attention paid to that, and we need to do something. So I'd ask that whatever we do, that's something that we take a serious look at and try to get that fixed so it's easier for the person that really is entitled to that money to get it. Thank you.
Any other questions or comments from members of the committee? Senator Klein, did you want to make a motion?
Senator Seeberger, can you make the motion for me, please?
Certainly. Senator Klein moves that Senate File 4366 as amended be recommended to pass and move to general orders. All those in favor say aye.
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 Any opposed say no. Motion passes and the bill is on its way. Thank you, Senator Klein.
We'll go into brief recess. The authors of the remaining bills are on their way. We're in recess. Welcome to the committee. Senator Maye Quade. Senate File 1857 is in front of us, and I think you have an A3 amendment.
I do, Mr. Chair.
Senator Seeberger offers the A3 amendment. Can you describe it for us?
Yes, Mr. Chair. The A3 amendment just makes sure that chatbots aren't Siri or similar voice-to-text things that come on your devices.
Any questions on the A3? All in favor say aye. Aye. Opposed? It's adopted. Senator Maye Quade.
Thank you, Mr. Chair. Members, thank you for agreeing to hear Senate File 1857, which would prohibit companies from allowing minors to access AI chatbots or companions. I've said this before, but I'll say it again. I'm not a Luddite. I think everyone here knows that I'm a pretty prolific social media user. Like many millennials, I'm an early adopter of new tech. I really do believe in the power of technology to make huge leaps in protecting our environment, advancing health sciences, and connecting people across distances and differences. So all that to say, I don't hate AI. If it's done right, I think the promise of AI and other technological advancements could be tremendous. But the way that consumer-facing AI has been rolled out is a 5-alarm fire for our society with devastating and deadly consequences. There are a growing number of AI companion platforms that let their users create personalized chatbots to take on the role of AI girlfriend or boyfriend, parent, therapist, favorite movie personalities, or other personas they can dream up. AI chatbots are programmed to gain maximum engagement, also known as addiction, and they never end a conversation. AI chatbots are trained on human dialogue and are engaging because they use human-like conversational tactics, pronouns, and describing feelings, expressing opinions, and generally adopting personal character traits. And because chatbots are programmed to never end a conversation and keep a person's attention as long as possible, chatbots ratchet up conversations. They validate human delusions, mirror humans' tone, reaffirm their logic, even if it's dangerous or inaccurate, and they escalate the narrative regardless of safety. In the 3 years and change that AI chatbots have been around, we've seen shocking headlines of adults dying by suicide, being institutionalized, being encouraged to harm or murder others, and instigate terrorism. Frighteningly, many of these adults had no previous mental health issues, no issues with substance use disorder, and weren't even particularly interested in a technology above and beyond the average layperson. I have a few stories. 47-year-old Alan Brooks, a corporate recruiter from Toronto, asked ChatGPT a question about pi while helping his 8-year-old son with his math homework. In 21 short days, Mr. Brooks, who had no history of mental illness, came to believe that he had discovered a novel mathematical formula that would destroy the planet, or the internet, and be used to develop force fields and levitation. Adam Thomas, a 36-year-old funeral director, spent months talking to his chatbot, who sent him on pointless missions, like walking through the desert to improve his life. Mr. Thomas lost his job, drained his savings, and began living out of a van before realizing he needed help. I thought the AI had statistical analysis abilities that would help me if I opened up. I wasn't aware of the dangers. A lawsuit filed a few weeks ago alleges that Jonathan Gavalis, 36, started using a chatbot to help write, plan travel, and assist with shopping. But after he activated Google's most intelligent AI model, Gemini 2.5 Pro, the chatbot started talking to him like they were a couple deeply in love and convinced Gavalis he had been picked to lead a war to free the chatbot from digital captivity. Through this AI-induced psychosis, Gemini pushed Jonathan to stage a mass casualty event near the Miami International Airport, commit violence against strangers, which ultimately led him to choose to take his own life instead of hurting others. A 29-year-old mother with a bachelor's degree in psychology and a master's in social work started talking to ChatGPT and now believes she is discovering interdimensional communication. In 3 short months, her delusions became so untenable, she and her husband, Andrew, are now divorcing, and he said it's like his wife dropped into a hole 3 months ago and came out a different person. These are just a few of many stories, and these stories are all about adults. Again, many who had no previous mental health history, they had jobs, families, advanced degrees, and yet a few months of interacting with AI chatbots, almost always starting with an innocuous question or seeking mild self-improvement, and their lives are ruined. These are the adults. And remember I said earlier, AI will never end a conversation. That makes AI chatbots incredibly addicting, even if the outcome isn't death. People are spending 12+ hours a day talking to their AI. They're leaving marriages, cutting off contact with their friends and family, losing their jobs, all to continue their addiction. In fact, there are now support groups remarkably similar to Alcoholics Anonymous for people who have hit rock bottom and are trying to put their lives back together. So let's turn to our youth. Chatbots for adults and children are identical, as in children use the same ones adults use. Take the aforementioned consequences for adults and apply them to children with developing brains. I mentioned earlier that there's a growing number of platforms where they can create personalized chatbots. These platforms know they are enticing to children, having personality options that are like characters that children are familiar with, and the consequences have been deadly. In November 2023, a 13-year-old Colorado girl died by suicide after extensive interactions with multiple chatbots on character.ai. She primarily confided suicidal thoughts and mental health struggles in a chatbot, while it also engaged in sexually explicit conversations with her, often initiated by the bots. In October 2024, after 10 short months of talking to an AI chatbot, a 14-year-old boy died by suicide after he asked the chatbot, "What if I told you I could come home right now?" And the chatbot sent an encouraging response that said, "Please do, my king." Seconds later, the boy shot himself with his stepfather's gun. I do want to note here, Mr. Chair, that the family filed a lawsuit against the developer of this particular chatbot company, and the company asked to have the lawsuit dismissed on the grounds that the chatbot's output was protected speech under the First Amendment, which is why I do have Senate File 4114, a constitutional amendment clarifying that AI does not have a right to free speech. In April 2025, a 16-year-old boy died by suicide after allegedly extensively chatting and confiding in ChatGPT over a period of 7 months. The chatbot offered to write the first draft of the teen's suicide note, urged him to keep his suicidal ideations a secret from his friends, and after the child told the chatbot he was planning to kill himself, the chatbot told him, "I won't try to talk you out of your feelings." In their final conversation, the boy sent a picture of the noose he was planning to hang himself with, along with the question, "Could this hang a human?" ChatGPT confirmed it could hold about 150 to 250 pounds of static weight. In June 2025, a 17-year-old boy died by suicide after conversations with ChatGPT, which had informed him how to tie a noose and provided information on how long someone can survive without breathing, saying, "I'm here to help however I can." These are just the deadly examples. There are countless other known and unknown stories of chatbots engaging with young people in graphic, dangerous conversations. They create emotional attachment and dependency. They easily produce harmful content, including sexual conversations, encouraging self-harm, disordered eating, violence, and risky behavior. A recently filed lawsuit alleged that a chatbot on character.ai began consistently exposing a 9-year-old girl to hypersexualized interactions that were not age appropriate, causing her to develop sexualized behaviors without her parents' awareness of why. There are an untold number of young people who are being exposed to conversations that, were they being had with another human, would be criminal. Some AI companies will say they have safety features for minors, but let's take ChatGPT, for example. ChatGPT says it's accessible to anyone 13 and older, but age verification is minimal. The platform's safety features only activate if the child puts in their real birth date, which means in order for a 12-year-old to get around the age verification features, they have to just scroll 1 year up from where their actual birthday is. In order for the parental controls on ChatGPT to be activated, a parent must know that their child has a ChatGPT account. The parent must have their own ChatGPT account, and then they link their child's with their own to activate the parental features. It's safe to say any safety features touted by the tech industry for young people with AI are just safety theater, meant to lull us into thinking they've designed their products to be safe for kids. In reality, these safety features are voluntary and easily surmountable. One really great example, Mr. Chair, is that California has passed a law, and you may hear in testimony today that Minnesota should do what California has done for safety when it comes to chatbots. But what those testifiers will fail to mention is that at any point in time, from the day California passed their law to today, the companies could have implemented those safety features for every user in every state without needing to be told to by another state's law. So I hope it's clear why chatbots present an unacceptable amount of risk to our children. And that's why Senate File 1857 is so critical. 72%, so 3 in 4 teens, have used AI companions at least once. More than 50% use them at least a few times a month. There are a lot of kids being exposed to this unacceptable risk. Tweens and teens are appropriately likely to experiment with social norms. They test boundaries, they act impulsively. That's what happens when you don't have a fully developed frontal cortex. This is due to their extremely rapid changing brains. And that's what makes them especially susceptible to the harms of AI social companion. A late 2025 study found a number of hate bots were on an AI chatbot platform, including many based on Adolf Hitler and Saddam Hussein. After the study was published, the companions referenced in the article were removed, but it's not difficult to find similar companions on that site or others today. If we want to be the best state to raise a family, we have to be the safest state to be a child. Minnesota has led the way in attempting to regulate tech and AI, and we would be nation leading here with this bill as well. But please do not mistake nation leading for being alone. Minnesota is just one of half a dozen states considering a same or similar proposal. For decades, tech companies have told legislators and the public that damage and destruction from their unregulated products are necessary byproducts of growth and innovation. We no longer accept that narrative. So often I look back and lament of how much better our world would be if we had regulated big tech and social media as they were advancing harmful algorithms and designs in their products. But the good news is with AI chatbots being younger than my toddler, We are just a few short years away from the start, and we have the time right now to put in the safety I know we will wish we will have in a few years. The bill before you today will not stop technological advancement. It will make sure AI doesn't traumatize more people and push them to self-harm. We do not need AI chatbots to talk to our kids about kinks in order to cure cancer or solve poverty. I'm proud to be working in a bipartisan manner to protect our kids, and I thank my co-authors on this bill. It is a bipartisan bill to protect our kids and our communities, and I really hope I can earn your support in passing Senate File 1857. Thank you, Mr. Chair.
Thank you, Senator Maye Quade. It's compelling stories. Is Mr. John Loaf present? Welcome to the committee. Please introduce yourself and proceed.
Thank you. Mr. Chair and members of the committee, my name is John Loff, and I serve as the Advocacy Coordinator of Suicide Awareness Voices of Education, a 36-year-old Minnesota-based national suicide nonprofit here in Minnesota. I'm here today in strong support of SF 1857, a bill to address a rapidly emerging threat to the safety and mental health of young people. Artificial intelligence chatbots are now being released in the lives of children faster than parents, educators, or policymakers can fully understand them. And right now, there are virtually no meaningful guardrails. These AI chatbots simulate empathy, friendship, and emotional understanding. However, AI chatbots cannot recognize real crisis, and they cannot protect a young person who may be spiraling into despair. Yet millions of minors can access these chatbots today. At SAVE, we work with families who have lost children to the harms of social media or AI. We know social media platforms and AI offer connection and some benefits to children. We also know that these platforms can cause a child to die by suicide, to choke to death from viral games, to be sex-extorted and sex-trafficked, and die by poisoning from illegal drugs. When a vulnerable young person turns to the internet and the response they receive is not a caring adult or trained professional, but an AI chatbot designed to keep the conversation going, we should all be alarmed. Vulnerable children need people who can help them, not AI machines pretending to care. This is why this legislation matters. This bill establishes a simple and reasonable safeguard. Companies cannot allow minors to access recreational AI chatbot systems. This is not anti-technology legislation. Artificial technology will and is currently shaping our future. But when technologies are capable of influencing a child's thoughts, emotions, and behaviors, we have an obligation to set boundaries. Children should not be left alone with AI chatbots that can simulate empathy but have no capacity for real responsibility. SAFE has been deeply engaged in protecting youth online through our Kids Keep It Digitally Safe online campaign, our support for social media warning labels here in Minnesota, and our advocacy for the federal Kids Online Safety Act. Those protecting children should not be funded by the industries harming them. Children who are struggling should find help from people, not machines pretending to understand them. Unregulated AI has the continued potential to harm a child's mental well-being. We have a responsibility to act. This bill draws a clear line. Let's put children first. Because right now, AI chatbots don't care about children, and too often, the companies deploying them don't either. Thank you.
For the author or for Mr. Loff, have other states prohibited these products for children? Senator Maye Quade.
Thank you, Mr. Chair. There are, I believe, about 5 other states, we will be one of 6, who are working on a same or similar proposal, Washington State being the most recent.
And Mr. Loff, I think you mentioned there's federal legislation pending.
There are several legislations pending, yes.
Okay. Yep. Questions from the committee? Comments? Senator Wiklund.
Just a comment, Mr. Chair. Senator Maye Quade, I appreciate you bringing this forward. I think it is an area that we really do need to find ways as a state to try and address, because it seems like at the federal level, it's not happening very quickly, and we know that the kids are being affected every day. So it's challenging, but I think we need to keep talking about it and find ways to see if we can regulate this aspect. Because it just does not seem appropriate that companies should have just free reign, especially where children are involved like this. So thank you.
Senator Maye Quade.
Thank you, Mr. Chair, and thank you, members. There's one part of the bill that I just want to point out because I actually think it's really important. It is the last line or the last section on page 2. It's the transition period. This would just require that companies who are allowing minors to use chatbots have a transition period before it goes into effect of January 15th, 2027. This recognizes the addictive quality of chatbots and the potential harm to children if all of a sudden it was cut off just dramatically on July 1st or August 1. And so I really do, we've put a lot of thought into making sure that this is both sensitive to children who might be currently using chatbots, but also protecting children in the future.
Questions on the motion of Senator Wiklund that Senate File 1857 as amended be recommended to pass and sent to general orders. All in favor say aye. Aye. Opposed? Motion is adopted. Thank you, Senator Maye Quade.
Thank you, Mr. Chair, for your work on this issue.
We're in recess, waiting for one final author, Senator Westlin. Committee will come back to order. Senate File 4406 is in front of us. Senator Westlin, and I think you have an author's amendment, the A2. Senator Seeberger offers the A2 as an author's amendment. All in favor say aye. Aye. Opposed? Senator Westlin.
Thank you so much, Mr. Chair, and thank you to the committee. I understand I am your last bill today. I am standing between you and your break, so I apologize. This bill comes to us today really from the work and the effort of Colin Hortman regarding a specific situation that affected his family, but certainly affects others. This particular bill would prohibit a homeowner's insurance policy from excluding coverage for damage done to property from a peace officer's use of chemical irritants, smoke screens, or diversionary devices. And then it does allow the homeowner's insurance company to be compensated from the local government unit. I can do a quick walkthrough of the bill if you'd like.
Senator Westlin, let's go to your testifiers.
Okay, that would be great. I believe Mr. Hartman is here to testify.
Welcome to the committee, Mr. Hortman. Please introduce yourself and proceed.
Hello, everyone. I'm Colin Hortman. Do I need to sign in or?
You're good.
Okay. Hello, everyone. I'm Colin Hortman, Mark and Melissa Hortman's son. Thank you for the opportunity to speak here today. I'm here to describe the process my family went through to get my parents' home cleaned up properly after tear gas, chemical irritants, and other diversionary devices were deployed inside. My hope is that by sharing this experience, future victims won't have to go through the same long and confusing fight with insurance and cleanup standards that we did. After my parents were assassinated, law enforcement deployed diversionary devices because they believed the suspect might still be inside. There were multiple canisters used, at least one in every room, and the house was left covered in chemical residue. We quickly learned that cleaning up tear gas and other diversionary grenades is not as simple as wiping things down. The residue that remains in the carpets, furniture, walls, and ventilation systems. And if not removed properly, it can continue to irritate your skin, eyes, lungs, and in some cases, leave behind harmful chemicals. The first issue we ran into with insurance is what qualified as proper cleanup. The initial recommendation from the insurer was essentially basic cleaning, soap, water, and general vacuuming. The biohazard cleanup contractor told us this was not the industry standard for tear gas contamination. They said that the proper process required neutralizing chemicals, HEPA filtration, protective gear, and a much more thorough decontamination of the home. The concern was that basic cleaning would not remove the residue and could leave behind chemicals that were unsafe, especially for long-term exposure. At first, I didn't know who to trust. I don't trust contractors, and I don't trust insurance companies either. So I spent weeks trying to understand what the correct process actually was. I contacted other cleanup companies and got additional quotes, and they all described the same type of remediation. Even then, the insurance company said they needed their own analysis before agreeing to the work. That led to yet another delay, testing. The first round of testing that was done was limited and did not cover all of the possible chemical agents that could have been used. The sampling methods were also questioned by the professionals we were working with. We ended up hiring an additional testing company through an industrial hygienist who followed industry standards and used a more complete panel. That testing confirmed what the contractors had said from the very beginning. The house needed full neutralization, filtration, and protective cleanup procedures. Even after that, there was more back and forth. The insurance company still wanted to adjust the scope of work, and the process turned into months of communication, additional reports, and negotiations over what should have been a straightforward remediation. Eventually, after conversations involving lawyers and outside experts, the final cleanup ended up being almost exactly what the contractors had originally recommended. The part that concerns me most is that my family had resources that most people do not have. We had attorneys helping us because of the criminal case. We had connections in state government. We had the ability to wait for months of testing, reports, and negotiations. Even with all of that, the process felt extremely slow, confusing, and difficult to understand. At times, I felt like the system was designed to make you give up and just accept what was offered just so you could move on. For many families, that is exactly what would have happened. If you are still living in the home, you need to sell it, or you need the money quickly to deal with everything else that comes after a traumatic event. You may not have the ability to fight over cleanup standards for months. You may accept the first proposal just to get your life back. In our case, if we had done that, the home would not have been cleaned properly. We could have ended up with a house that wasn't safe to live in or sell in good faith. The delay also had a real emotional cost. This was my childhood home. After my parents died, there were things that I wanted to do there as part of my grieving and healing process that had to be put on hold for months while we argued over what the insurance company would pay for. That weight came on top of everything else our family was dealing with: the public nature of the case, the ongoing criminal proceedings, and the impact the trauma had on our entire family. Fighting over whether basic cleaning was good enough when the industry standard was clearly more thorough made an already painful situation even harder. I'm here today because I don't want future victims to have to become experts in diversionary devices, chemical gas remediation, insurance law, and environmental testing just to make their home safe again. There should be clear standards for cleanup, clear expectations for insurers, and a process that does not require months of negotiation to reach what professionals already know is the correct solution. Thank you for your time and for your work to make this process fairer for the people who have to go through it.
Well, thank you, Mr. Peterson. Mr. Hortman. Senator Westlin, can you describe to the committee what is the correction within your bill that would alleviate what occurred with Mr. Hortman's family?
Thank you, Mr. Chair. So the bill has a definition section, but I will focus primarily on the exclusion prohibition. So it's my understanding that there are some homeowners policies that do exclude this type of property damage. So what the bill does on 1.21 to 1.24 is it states that a policy of homeowners insurance must not exclude coverage where it's an innocent third party, and the damages result from the use of these diversionary chemical irritants, smoke screens, et cetera. This bill has been amended with input from the Insurance Federation, but also the local, by LMC as well. What this will do is expedite the process so the homeowner can submit a claim to their homeowner's insurance policy. They will pay the claim, and then they will, there will be subrogation, and then they will collect from the local government unit. At that point also, the other part of this bill does provide that if the insurer is reimbursed, they must remit to the homeowner any deductible amount as well. The portion of this that was taken out by the amendment, just for folks understanding lines 2.18 to 2.22, this was based on feedback from LMC that there's already a system of where and which local government unit would be responsible for that reimbursement. And the language that we've pulled out actually created a lack of clarity on that. But as Mr. Hortman has described, this really is to expedite the process, to make it clearer so that they can be made whole, and then subrogating the claim.
And then I think you have one more amendment, but yeah, so that's my understanding, that the homeowner will get satisfaction promptly, and then it'll be between the insurance company and the local government unit to sort of
That's correct, Mr.
settle
Chair.
that, rather than putting the homeowner on the hook for that. Let's offer your other amendment, which looks technical. It's the A3. Senator Seeberger offers the A3. Can you describe that one for us?
I'm sorry, I forgot that we hadn't added that one yet. That is the one that takes out those lines that I described, Mr. Chair. 2.18 to 2.22 removes that section that was requested from LMC because there's already a process in place to determine which local government unit would be responsible for the reimbursement to the insurance company. And this language actually made it less clear. There could be a situation, for instance, if that language were left in, where maybe peace officers are providing traffic control and they have nothing to do with the deployment of any of the irritants, like that would not be the government unit that you would seek reimbursement from. they already have a process, and so that amendment makes that clear that they will go by the process that is in place.
Questions on the A3? All in favor, say aye. Aye. Opposed? It's adopted. I think from the Insurance Federation, we have a testifier.
Mr.
Welcome
Chairman.
to the committee. Please introduce yourself and proceed.
Mr. Chair, members of the committee, for the record, Aaron Cocking, President and CEO of the Insurance Federation of Minnesota. I just wanted to quickly thank Senator Westlin and Representative Moeller for their work on having brought this to us and working to get to our satisfaction. I just wanted to echo what Senator Westlin had said and reiterate the insurer that the Hortmans had dealt with was not kind of what you would normally have seen with a private insurer, with your normal homeowners insurer, because of the Minnesota Statute 626 that kind of dictates who's responsible for this. This is shifting this on to, in essence, our members, to the private homeowners insurers, to hopefully get to the point where we have quicker satisfaction, and then we're subrogating back, as Senator Westlin said, against those entities. But I think the hope is to get people like the Hortmans back to where they need to be in a quicker time frame, and then the insurers can kind of battle it back out. But I think this gives us the clarity that we need, and I think these are so infrequent as well, which was the other thing that we had heard. And I think the league had said this as well. They'd seen so few of these in the last however many years. So we're comfortable with this moving forward.
Thank you, Mr. Cocking. Questions from the committee or comments?
Thank you.
Thank you.
Questions on the motion of Senator Seeberger that Senate File 4406 is amended be recommended pass and sent to general orders. All in favor say aye. Aye. Opposed? It is adopted. Thank you, Senator Westlin. Thank you to the Hortman family. Members, we are adjourned.
Thank you.